Okay, so welcome to everyone to this book launch of a very interesting book by Sondra Faccio on indirect expropriation in international investment law. So we have formally a book launch, but mostly it will be a discussion about the book and the topic. So many thanks to the Society of International Economic Law for having co-organized this together with the author of the book, of course. And I personally find it a very interesting book. I find indirect expropriation generally probably one of the most tricky topics in international investment law. And I really find it very, first of all, courageous to engage the topic. And I find it a very nice addition to scholarship on the topic. So I'm very happy to be here to participate in this book launch. So we'll proceed as follow. I'll first give the floor to Professor Nesi. And then we'll have a discussion of the book by Professor Tarcisio Gazzini and Professor Chatarine Titi, and then Sondra Faccio will also offer some responses, and then we can open the floor to the virtual audience. So first of all, I give the floor to Professor Giuseppe Nesi, who is full professor of international law at the University of Trento and also former dean of the law faculty of the University of Trento, and previously he had also various other experiences as legal advisor to the President of the UN General Assembly and also as legal advisor to the Permanent Mission of Italy to the United Nations in New York. Professor Nesi, many thanks for being here, and I give you the floor for the introduction.
Thank you very much. Thank you, Professor de Brabandere. Thank you, Eric. It's always a pleasure to be among friends. And I must say that now the pleasure is even more acute, so to say, because the occasion to meet is the presentation, the launch of this book by Sondra Faccio, who, as you know, has been working both at the School of International Studies in Trento and at the law school. So it is really a pleasure and an honor for me to be here today. And I would like to start with quite an interesting citation by Sondra. It is very interesting how she started with general consideration the second chapter of the book, when she cites Konstantin Katsarov, a book on the theory of nationalization. There she spoke about the fact that Mr. Katsarov, Professor Katsarov, was speaking about to these fundamental instincts in man, the drive to appropriate and the instinct which drives him to seek the company of his fellows. Starting from this consideration, Sondra recalls that these fundamental instincts have taken form in two social institutions, namely property and the state. And there is, of course, an innate tension between the interest of the individual as a private owner and the interest of the individual as part of the community. This is something that takes the form in certain environment of expropriation, when private property is effectively subject to the claim of society. When the tension between the reason of the property and the reasons of the state occurs across state boundaries, it is international law which is called to reconcile the conflict. This is really the essence, so to say, of expropriation and of the role of international law in this matter. So provisions concerning direct and indirect expropriation are at the heart of the protection granted to foreign direct investment under international investment agreements and under international investment law. These provisions, on the one hand, recognize the sovereign power of the state to expropriate in the public interest, and on the other, introduce a series of conditions that the state shall meet to lawfully exercise its expropriatory power. And of course, I refer, as you know very well, to public purpose, due process, non-discrimination, and the payment of compensation to foreign investor. The main condition and the most important protection for the investor is compensation. Compensation represents the quantum of investment that cannot be neutralized by the expropriatory measures of the state and grant the equilibrium between the conflicting interests of the state and the investor. Today, indirect expropriation, as opposed to direct expropriation, represents the most serious and recurrent type of interference with foreign direct investments. Yet its definition, as you all know, is still characterized by great uncertainty and ambiguity. And this is the reason why I share the view by Eric that Sondra was very brave, very courageous in addressing this issue in her book. Based on the analysis of existing states' practice concerning investment negotiation, especially investment case law, Sondra's book proposes a model for the interpretation and application of provisions of indirect expropriation. The model aims to both identify clear-cut interpretative tools to detect cases of indirect expropriation and assure a fair balance between the interests of this foreign investor that should be protected and the interests of the state to regulate in pursuance of the public interest. The model is based on three pillars. First, the pure effect approach to identify cases of indirect expropriation. Second, the fair equitable treatment standard as the lower limit to indirect expropriation. And third, the application of proportionality in the quantum phase to assess the compensation. The model rationalizes the outcome of investor-state awards on the matter. Sondra collected and analyzed 49 publicly available cases from 1995 to 2018, in which indirect expropriation was found. These cases with the relevant parts are included in a table annexed to the book. The work also benefited from the review of 125 domestic laws on investment. These are the main features of Sondra Faccio's book. I think that much more will be said by the experts, by the commentators, Chatarine, Titi, and Tarcisio Gazzini, with the able guide by Eric de Brabandere, a true specialist on these issues. So I stop here and I thank you very much.
Thank you, Pepe. Thank you, Professor Nesi, for these introductory remarks. So now I pass the floor first to Professor Tarcisio Gazzini, and I'm very happy to have both Professor Gazzini and Professor Titi here, experts in the field. Professor Tarcisio Gazzini is Professor of International at the University of East Anglia in Norwich, previously also taught at the University of Padua, Glasgow, Free University of Amsterdam, and was also involved in a very interesting project on foreign investment in Africa at the University of Lausanne. He's also, amongst others, the author of an excellent book on treaty interpretation in international investment law. So I think he's the right person also to comment on the book. Tarci, you have the floor.
Thank you. It's a pleasure to contribute to this event and to discuss this very interesting book. The topic may not be extremely original anymore, but remains at once important, complex, as Eric said at the beginning, and also intriguing. The research carried out by Sondra is rigorous and thoughtful. The inquiry on arbitral decisions, in particular, is very impressive and is supported, as Beppe underlined, by a very useful table summarizing the leading decisions. The inquiry, nonetheless, is a bit unbalanced because treaty practice is not as rich and detailed as arbitral decisions. But there is no doubt that this is an important contribution to scholarship, and the topic is definitely complex and important. The author, nonetheless, was able to offer a very rigorous and systematic analysis. So I fully share the very good, the kind words by Eric and Pepe, and we should welcome this book as a very important contribution in this area. However, my role as discussant obliges me to go beyond the appreciation of the book and to make some comments. And today I got 3 comments. The first comment: the author has captured extremely well the difficulties in defining indirect expropriation, and even more in determining in practice whether indirect expropriation has occurred and what are the consequences, especially from the point of view of compensation. As it is often the case in foreign investment law, but probably in law in general, the challenge is to strike a balance between different rights and interests. And in this case, we have on one hand the need to safeguard the regulatory powers of the host state, and on the other hand, the need to provide for an investor an adequate legal protection against expropriation, which is probably the worst case scenario, the nightmare of investors. It is undisputed that the host state is entitled to exercise its regulatory powers with regard to all subjects within its jurisdiction, including foreign investors. It is a right and a duty of the state to regulate in order to protect public interest. And the other way around, foreign investors may obviously comply with all relevant local laws and regulations, to the point that arbitral tribunals have often decided that non-compliance may imply losing the protection of the treaty. It is also undisputed that the exercise in good faith and in a non-discriminatory manner by the host state of regulatory powers may have detrimental effects, detrimental economic effects for the foreign investor, without triggering any obligation to compensate. Yet there is a line, and this is our major problem. There is a line dividing good faith exercise of regulatory powers, which does not trigger any obligation to compensate, from indirect expropriation, which on the contrary implies a duty to compensate. And whether the state has crossed the line is extremely difficult, must be determined on a case-by-case basis, and indeed is the essence of the indirect expropriation and the main question behind this book, as any book on indirect expropriation. But it is important to emphasize that this is not peculiar to foreign investment law. We have the same problem also in domestic law. Take, for instance, the example of the United States. They don't use the term indirect expropriation. They use the term regulatory taking, but the essence is the same. Again, we need to strike a balance. The state needs to regulate and possibly affect the right to private property, but at the same time, you need to protect the holder of the rights. And We have a number of cases before the US Supreme Court. And interestingly, Justice Holmes, one of the most influential judges in the Supreme Court, described regulatory taking as situations in which the government has gone too far, which is basically the equivalent of crossing the line. So there is a point in which the obligation to compensate will be triggered. Doesn't matter whether it's domestic dimension or foreign investment law. And as explained very well by Sondra in the book, tribunals in search of this line, in order to draw the line dividing good faith regulatory powers and indirect expropriation, tribunals have resorted to three main approaches. The pure effects approach, which focuses on the impact, the negative impact of the measure or the series of measures adopted by the host state. Second, the policy power approach, which on the contrary focuses on the exercise of regulatory powers, the nature of the action by the state, the purpose, and so on. And third, in a sense, a combination of the previous two, the application of proportionality in search of an equilibrium between public purpose of the measure adopted by the host state and the negative impact suffered by the foreign investor. And here, many tribunals have looked at the jurisprudence of the European Court of Human Rights. Now, distinguishing the three approaches is necessary and important. But in my opinion, tribunals and also states, through the conclusion of investment agreements, tend to apply them in combination, often indicating a series of elements to take into account in order to draw the line dividing good faith regulatory powers and indirect expropriation. And a good example is the expropriation annex to the agreement between the US and Canada, the CETA, the Comprehensive Economic Trade Agreement. So the parties included a very sophisticated provision on expropriation in the text of the treaty. And then they felt the need to add an annex specifically on expropriation. And in the annex, they refer to a number of factors tribunals could take into account, including, of course, the economic impact caused by the measure or the series of measures, the duration of these measures, the extent of the measure, the character, including the object, the context, and the intent of these measures. And it's a non-comprehensive list. So tribunals should, on a case-by-case basis, take into account these factors and possibly other factors, depending on the circumstances of the case. I will go back to this point later. And here, in my opinion, the author could have investigated a bit more on this point, the combined application of the three approaches, especially because the author rightly referred to a number of very interesting cases in which tribunals applied this combined approach, like the Bear Creek, Chemtura, Philip Morris versus Uruguay. And the author also observed that these factors do not have necessarily the same weight. And here is where the tribunal needs to balance all the relevant factors in the specific case. The second comment relates to the relationship between indirect expropriation and fair and equitable treatment, which I presume must be understood here as referring to fair and equitable treatment, but also the minimum standard of treatment. This point maybe Sondra will clarify later. The author has suggested that minor interferences, which means interferences not serious enough to be qualified as indirect expropriation, may be treated from the standpoint of fair and equitable treatment, which is defined as a catch-all provision. This approach is very intriguing, but in my opinion is not entirely convincing for two reasons. First of all, it would upset the balance struck between good faith exercise of regulatory powers and indirect expropriation, the famous line dividing the two. And however difficult it is to define the line, the basic point behind indirect expropriation is that up to a certain point, the host state has the right and also the duty to regulate in order to protect public interest without having to pay any compensation, even if the measure or the series of measures adopted may have negative consequences for the investor. In my opinion, introducing fair and equitable treatment as a catch-all provision would jeopardize the regulatory space of the host state. And the second reason, which is related, concerns the nature of the two standards, indirect expropriation and fair and equitable treatment. There is no doubt that the same measure or the same series of measures may amount at once to a violation of both indirect expropriation and fair and equitable treatment. There is a certain overlap between the two provisions. But in my opinion, fair and equitable treatment is intended to protect foreign investors generally in all their interactions with the host state and its organs, including domestic tribunals. The famous concrete principles elaborated by investment tribunals in order to flesh out the meaning of fair and equitable treatment, for instance, in Rumeli versus Uzbekistan, are not necessarily related to the exercise of regulatory powers. Most of them, they have nothing to do with regulatory powers. And the standards, in my opinion, must be applied, can be applied to the same measure or the same series of measures, but they must be kept distinct. Otherwise, we risk to mix apples and oranges. The third, last and short comment is about the level of deference arbitral tribunal should show in dealing with indirect expropriation cases. The author has rightly referred to the agreement between Korea and India, according to which the exercise of regulatory powers may amount to indirect expropriation only in rare circumstances. And the expression in rare circumstances is very popular in North America and now has been exported elsewhere. And for instance, can be found in the CETA agreement, the agreement between the European Union and Canada. And of course, the idea behind this provision, the inclusion of in rare circumstances, is to introduce an extremely strong presumption against indirect expropriation, or from a different perspective, to build up a very solid defense against claims of indirect expropriation. Or in other words, is a clear attempt to draw the line dividing regulatory powers and indirect expropriation in a manifestly in favor of the host state, because it would be awfully difficult for foreign investors to prove and convince a tribunal that there is a case of indirect expropriation. And in my opinion, this is also crucial, the way tribunals should assess claims of indirect expropriation. And recent practice offers a number of interesting developments, including, for instance, the Indian model bit. But I better stop here, and I must clarify that these are comments and potentially suggestions for further analysis and further research than criticism. Okay, so my role of discussant imposes me to say something balanced. Otherwise, the exercise would have been suspicious. But I want to finish by reiterating the basic point. This is an important contribution. It offers a very rigorous and systematic analysis of an extremely difficult topic. So well done, Sondra. And now I stop here. Thank you.
Thanks very much, Tarcisio, for this well-balanced discussion. It's not an easy task, but I think you did a great job. So many thanks for that. So I suggest to first give the floor to our other discussant, and then we'll move to Sondra Faccio for comments on both discussions. So I now gladly give the floor to Dr. Chatarine Titi, who's a tenured research associate professor at the French CNRS. And affiliated to the University of Paris 2, Panthéon-Assas. She's also a member of the board of the European Society of International Law, member of the steering committee of the Academic Forum on ISDS, amongst others, and also author of a book on the right to regulate, which is precisely the subtitle of the book by Sondra Faccio on indirect expropriation. The subtitle is Between State Regulatory Powers and Investment Protection. So Chatarine is, of course, very well placed also to discuss this. So Chatarine, you have the floor.
Thank you very much, Eric. Thank you, Sondra, for the invitation. It is very nice to be here in good company. I would like to start by congratulating Sondra on her excellent book. The topic, I think, is very challenging because in a way it is so mainstream that it takes courage to deal with it and give a new approach. And I think that Sondra does give a new approach to the topic. I found particularly interesting the fact that Sondra deals in the book with indirect expropriation in conjunction with the fair and equitable treatment standard. So the fair and equitable treatment standard has quite a prominent position in the book, and I think this is very interesting. Also, I found very interesting this focus on compensation. So what is indirect expropriation? Rather, ultimately, what does matter is whether the state has a duty to compensate and how much it has to compensate. So I think these are very important questions, and Sondra has very rightly put them there. Also, I found interesting this discussion of the need for a search for a balance in the compensation phase. I'm not saying that I agree with everything in the book, but of course we can't all agree on everything. But I think the approach is actually very interesting and very useful, and it offers new perspectives. And following from what I've been saying, and mainly from what Sondra has written in the book about the fair and equitable treatment standard as a catch-all standard, I have a question, and the question is there a need for the indirect expropriation standard if the treaty has a fair and equitable treatment provision? And I don't want to claim the authorship of this comment. Actually, Professor Shotaro Hamamoto has written an article which is entitled something like A Requiem for Indirect Expropriation with a question mark, and he asks these questions. So I'm taking his question to ask Sondra. There was this discussion from a little more than 10 years ago now, that tribunals take into account regulatory flexibility in their interpretation. So as Eric mentioned, I worked on the right to regulate. That was my PhD, and there I had taken a stance against everyone who was saying that tribunals do take into account regulatory flexibility, so it doesn't have to be incorporated in investment treaties. I say this with a caveat that I think a lot has changed since that time. But what I wanted to say was that when you look at the case law, and at least the older case law, the tribunals that, and this is something that rightly Sondra points out, the tribunals that would not find a violation of the indirect expropriation standard would then go on and find a violation of the FET standard. Obviously not all tribunals, but the tribunals that were often used as examples of tribunals take into account regulatory flexibility. But when you looked at the decision, when you looked at the award, in fact, they seem to take into account regulatory flexibility when they were interpreting the indirect expropriation standard. But then when it came to applying the fair and equitable treatment standard, they found a violation anyway. Again, I think things have changed quite considerably from 10 years ago. And this leads me to my next question for Sondra. And that is, have you found that there has been an evolution in the interpretation of indirect expropriation in the last 10 years, maybe in conjunction with fair and equitable treatment? And if so, what is this evolution? So my question is really, do we find that tribunals are more hesitant about finding a violation of these standards as a result of the backlash against investment arbitration? And the thing that makes me think about this is, I remember the Philip Morris cases. So when the two Philip Morris cases were still pending, there were all these I don't know, posts, articles by civil society saying, oh, these tribunals, look at what they do. We have public interest measures, and we have these arbitrations. And of course, in the two cases, the tribunals rejected the case. In one case on jurisdictional grounds, and in the other case because the tribunal applied in the Philip Morris versus Uruguay case, the tribunal applied the police powers doctrine. So I was wondering, is that evidence of a more general trend that tribunals, at least when it comes to the substantive law, they're more likely, for example, to find that the police powers doctrine applies, taking into account everything else, the impact of the financial impact of the measure and the relevant circumstances. My final comment relates to equity. It's a topic that is close to my heart because I spent the last 2 years working on it. My new monograph on the function of equity in international law will appear 1 month from today in Oxford University Press. I found very interesting the discussion about equity in the context of compensation. I know Sondra distinguished equity from proportionality and reasonableness, and of course the concepts are distinct, although I would argue that proportionality and reasonableness are themselves equitable principles, variations on equity or derivations of equity. But I liked that Sondra in the book discussed equity as taking into account the specific circumstances of the particular case, rather than as an extra legal concept, because there are many colleagues who would discuss equity as an extra legal concept. And I fully agree with Sondra that equity is not an extra legal concept, it is part of the law. One of the issues that I think is very interesting about this is that equity is in fact used a lot in order to assist tribunals, also international courts, when it comes to calculating compensation. And also this is the context in which Sondra discusses it in the book. And I would also like to say that in addition, it's also used in related decisions that tribunals make, such as decisions on costs, decisions on security, whether to post security for costs, and so on. And of course, this is normal because often it is difficult to choose between different valuation methods. The treaty text may be unclear about exactly how to calculate compensation, and so on. This and And then there's the maybe final issue, the distinction that also Sondra draws in the book between irregular equity and the use of the exequat bono mandate. I mean, of course, the two are different. An exequat bono mandate requires the parties' agreement, and when and if it is given, the reasoning does not need to start from a textual analysis of the law. The tribunal can go ahead and start by applying equity without explaining. So there's a lighter, the need for reasoning, the need to state reasons is somewhat lighter, and it is used quite restrictively, however. So even in this case, the tribunals, in the less than a handful of cases, that investment arbitration cases that we have, again, the exequat bono mandate was used especially to determine compensation and interest, so in this same context, and quite restrictively. So essentially, they seem to have reached a decision that more or less could have been reached even without this mandate. So I think it is very interesting that Sondra has given this perspective in the book, and I think it is a rare perspective, because I have seen equity discussed in the context of compensation, and it was seen with skepticism. But I liked Sondra's approach. I agree with Sondra's approach on this matter, and this explanation that in this case it is often just taking into account the circumstances, the particular circumstances of the case, rather than jumping on to something that is outside the law. So I will close by congratulating again Sondra for this very interesting book. It has been a pleasure reading the book. And again, congratulations. Thank you very much.
Thank you very much, Dr. Titi, Dr. Chatarine, for these comments. Sondra, it's up to you now to offer some remarks or comments or answers, or attempts of answer, up to you to try and rebut the criticism or the invitations for further developments.
Yes, thank you, Professor de Brabandere, and thank you, Chatarine, Titi, and Tarcisio, Gazzini for the comments and criticism to some parts of the book, and thank you, Professor Nesi, for the kind introduction. Of course, I'm completely aware that I engaged in a study, in a work which is quite challenging, and where many scholars have dealt with the issue before me in excellent ways. So I don't pretend to give a definitive answer to the topic, just to contribute a little further to develop the study around this hot topic that is indirect expropriation. Starting from Tarcisio comments, and I think I will cover also a few comments of Chatarine on the same issue, that he is, first of all, Tarcisio said that having a look to the case law, not only, I mean, the pure effects approach was not employed in a vacuum, but it was employed together, mixed, let's say, with the other approach, the police power or proportionality, or even engaging with the employment of other criteria, such frustration, for instance, of legitimate expectation was also taken into account in the assessment of indirect expropriation. And so taking from this, that's true. I mean, the analysis of the case law show exactly that tribunals, in some cases, not in all cases, but in a number of cases, actually not only took into consideration the effects produced by the measure adopted by the state or the series of measure, but also other elements that could be proportionality, or could be frustration of legitimate expectations. As I said, sometimes they even quoted the police power doctrine. That's true, it's a combination, but what comes out from the analysis that I've carried out is that even though other elements are considered, the most important factor that determine a finding of an indirect expropriation is always the impact of the measure on the ownership rights, let's say, of the investor. So the capacity of the investor to use, enjoy, and dispose of the investment. The effects, the mayor comes out as the central factor, this condition sine qua non, even though there could be also proportionality analysis. There's a very interesting and quite, I think, representative quotation from Perenco that basically says, even though there's some proportionality, could say with application proportionality, we comes to an assessment of disproportionate outcome. This is not enough to say we have an indirect expropriation if the effect doesn't point to that direction, to this direction. So the effect remain the prevailing element. Staying on the analysis of the case law, I noticed, and then leads me to the second comment that comes from both from Tarcisio and Chatarine concerning the relationship with the fair and equitable treatment standard. Basically, I've noticed that there was not in the scope of the research at the beginning, but I noticed in many cases, also in recent cases, for instance, involving the solar energy case law in Spain and Italy, that once arbitrators dismissed the case as, or the measure as indirect expropriation, so arguing the effect could not be considered as such to represent an indirect expropriation, then they turned literally to assess the same effects for the purpose of the fair and equitable treatment standard, stating, and with, I can't quote exact wording, but wording similar to, this effect does not amount to a violation of the treaty in relation to the indirect expropriation provision, but let's see whether they can strike a violation of the fair and equitable treatment. So I focused a little bit on those cases. The book analyzed a number of cases in the Argentina context and a number of more recent cases involving the repealing of incentives in the solar energy sector. In at least two cases that I've mentioned as example in the book, I noticed that the same analysis carried out for indirect expropriation is then translated into taking into consideration the effects together with the frustration of the legitimate expectation in the assessment of the fair and equitable treatment standard. I've also noticed that the assessment of the legitimate, whether there was a frustration of the legitimate expectations, an element it is also taken into consideration sometimes in the assessment of indirect expropriation, and therefore I've noticed that basically fair and equitable treatment in those cases is employed as an alternative, as a lower limit. I've called that a lower limit to indirect expropriation, as the analysis showed that, and that was also argued by other scholars before me, that it seems that the obligation of the states under indirect expropriation and fair and equitable treatment sometimes does not differ much on quality, but more on the intensity of the violation and the measure and the effects of the measure. Building the fair and equitable treatment standards as a lower limit to indirect expropriation to catch all violation interferences with the right of property with investment that does not amount to indirect expropriation was fascinating, because I've noticed that in other systems, for instance, the European Court of Human Rights system that apply and interpret Article 1, Protocol 1 of the European Convention on Human Rights, take from the provision of Article 1 a residual clause that is taken from the general statement of the first paragraph of Article 1 that uses a sort of catch-all clause to cover all interferences that are not disposal, and which are not, sorry, deprivation of the property rights of the individual in this case. And therefore, I noticed that this tendency to have a sort of catch-all clause to cover such minor interferences with the right to property was also used in other systems. Also, if you have a look to the Iran United States case law, you see that it elaborates, the tribunal elaborates a sort of, also in this case, a sort of catch-all clause, which is other measures affecting the investment, which are not expropriation. So sort of reservoir, also in this case, to cover all interferences, which was a fact, does not amount to a veritable expropriation. And therefore, starting from that and noticing this trend in investment case law, I've elaborated, or I thought of fair equitable treatment applied as a lower limit to indirect expropriation. Professor Balde argued that this tendency to employ to argue that the difference between the two standards is not a question of quality but intensity somehow comes from the employment of the analysis of the frustration of the legitimate expectation of the investors that is employed in both cases. Then Chatarine asked whether sorry, that I haven't said before, whether the police power doctrine has been employed and therefore take into account the regulatory power of the state in new cases, whether there's new trends on that. Actually, in the cases analyzed, I found that the police power doctrine was mentioned just in 3 cases, around 3 cases, and in those cases, the police power doctrine was considered was of course considered either under customary international law and under treaty law. There was a provision in the treaty in the specific case where this was discussed, which is the case CC Devas versus India. In that specific case, for instance, the police power doctrine was considered, but then dismissed its application because the measures of the states were considered to be unreasonable, and therefore the police power doctrine was not at the end applied. But the application of the police power comes both that is interesting from customary law and both treaty law, because there was an express provision in the treaty, and therefore was assessed the right to regulate of the state in light of the specific provision of that treaty. In another case, which I think involved also India, police power doctrine was mentioned because the state basically interfered with the property, with investment of the foreign investors to create military bases. So there was a sort of actually a public interest to be satisfied. The measure was considered not to be expropriatory to the extent the measure was actually directed to this purpose, so to create the military bases. For the part, because the state adopted other reasons together with this public interest, and not all the investment taken was used for those this specific reason, the remaining part was considered an expropriation. So that's the 2 cases that I can illustrate from the analysis. And yes, concerning new cases and the relation between the fair equitable treatment standard and indirect expropriation new cases, as I said, in some solar energy case law, it emerged that the fair equitable treatment standard was assessed along the same line of indirect expropriation using the facts. So the question is worth to keep indirect expropriation when we have the fair and equitable treatment standard? Good question. I would say, I think I would answer taking into account how I suggest to interpret, to apply, to qualify better a measure as expropriatory under the book. What I suggest is that an indirect expropriation shall occur when there's an interference which is nullifying, is attaching upon one of the fundamental rights of the owner. So when the right to use, dispose, or enjoy of the investment is basically nullified, neutralized by the measure of the state, when the effect of this neutralization is to render the investments, the business worthless for the investor, and when this interference is not temporary and is definitive, it could not be reversed. This type of interference leads to usually to identify, based on the case law that I've analyzed, not much general measure, but general measure that could be general, like a travel ban, but are going to affect really specific rights of a specific investor, and therefore makes the identification of indirect expropriation measure very close to what is usually a direct expropriation, and which reflect also what was the initial purpose of this type of provision when it was elaborated. So such measures that are general measures that are misused to then affect the interest of the investors. Giving this interpretation of indirect expropriation would say that the fair and equitable treatment may still play a role, and it may play a role because it takes into consideration other elements, not only the interferences, as I said, the interference with the effects, even though these represent an important factor taken into consideration by arbitration draws cases, but also other elements such as the frustration of the legitimate expectations. So not only minor interferences with the property, the property right, I would say, or the property of the investment, but also minor interferences, but also other elements such as the frustration of the legitimate expectation of the investor. Coming to the compensation aspect, that was the part where compensation represents the most important, is the pillar, in my opinion, of the provision of on expropriation and indirect expropriation. It is exactly the equilibrium between the right of the state to expropriate and the right of the investor, or the interest of the investor to be protected, is exactly struck through the provision of a compensation. The compensation recreates the equilibrium breached by the measure taken by the state. And therefore, I thought that exactly in the assessment of compensation, tribunal should make an effort to make a result, make a quantification and assessment which reflect and respect the interest involved and the specific circumstances of the case at hand. Concerning equity in this stage, equity is analyzed together with other criteria that I've noticed have been employed by arbitrators in the assessment of compensation or compensation for damages in investor states cases. Equity is just one of the criteria employed, another being reasonableness and proportionality. Equity is employed specifically to make justice in this particular case by arbitrators, and to, as I said, take into consideration all the circumstances at stake to shape the quantification in a way which satisfies the reality of the case. Equity, however, is not usually detailed. It's not a process. I mean, when arbitrators decide through equity, they don't detail exactly what is the process they undertake. And that's why I've suggested a different model based on proportionality, because proportionality is not allow for a balance of elements and therefore provide for a structure to be employed by arbitrators. I've in the analysis of the case law, I've detected a number of elements that usually and recurrently arbitrators take into consideration, and I've tried to rationalize the outcome on investor state arbitration awards on that, and list a number of elements that could be taken into consideration through a proportionality analysis. The proportionality analysis, however, does not replace the application of valuation system based, for instance, to assess the fair and equitable, the fair market values based, for instance, on the discounted cash flow method or other valuation method adopted by arbitrators, but is employed afterwards to verify whether the monetary outcome arrived through this valuation process is proportional to the specific circumstances at stake, and therefore to assess whether it could be better shaped to take into consideration those elements. I believe, I know that the application proportionality could be considered critical in this phase, not striking precision or giving precise parameters for the quantification of compensation, but I also think the main element is for arbitrators to explain exactly in the award how they quantify the compensation through the valuation. I don't know how this was assessed and how it is proportional with the specific circumstances at stake. Equity, by contrast, I thought, even though proportionality and reasonableness could be qualified as something that is covered by equity or production of equity, elaboration of this principle when not offering a structure such as proportionality for helping the balancing of the elements and the specific circumstances at stake. Perhaps I'm missing other questions. Another comment concerned that the consideration of investment treaties, that investment treaties were not taken into consideration much in the book, and the fact that those treaties provide for certain additional elements, such as the annex to the CETA, additional elements for arbitrators to detect cases of indirect expropriation, and therefore these elements may not rely exclusively on the effects. Effects is just one of the elements mentioned, together with others such as proportionality and non-discrimination, for instance. That's true, but again, I haven't seen cases where CETA has been applied yet, or treaty where provisions similar to those were applied, or at least are not covered from my analysis. What I've found out that actually, and again, that these other elements are taken into consideration, but not as the decisive element. The effects strike always the decision towards a finding of indirect expropriation. Also, the wording of these provisions that says, except in rare circumstances, I would say a reasonable general regulation does not amount to indirect expropriation. Usually use this type of wording. In contrario, it may says that there are circumstances where general regulation may amount to a form of indirect expropriation, and those rare circumstances is exactly when, from my analysis, when exactly the effects of the measure taken by the states can be equated to the effect of a direct expropriation. That happens, in my opinion, when the three elements that I've mentioned are met. So when there's a nullification or annulment of one of the prerogatives of the property, the right of, usually related to the right to property, and therefore use, disposal, and enjoyment, when there's a significant economic impact on the business viability of the investment, and the definitive effect of that, and not temporary effect of the measure.
Thank you. Thank you, Sondra, for offering these additional comments on your book, and in reply to the comments by Tarcisio and Chatarine. So a lot of food for thought, actually. I think also in the discussion re-emphasizes not only the importance of the topic, but also the complexity of the topic. And I'm also, to be honest, Sondra, very happy that you relate much to existing cases also outside of the investment, or sort of the typical investment context. So questions of proportionality, European Code of Human Rights, but also the Erroneous Claims Tribunal, which I think is very important also. So we have a couple of questions from the audience. One of them, perhaps I'll put them to the group as a whole, and then we'll see whether Tarcisio, Chatarine, and Sondra wants to answer them. One I think is quite important, is interesting, is what role does codification have going forward? So what can treaties do, what should treaties do in the future in relation to indirect expropriation? I think it's an important topic, of course, because treaties are, of course, not only fundamental, but also probably one of the reasons why it's so complex and blurry. A second question that Chatarine also agreed to answer is whether a discriminatory but non-arbitrary regulatory measure that falls under a security exception clause can be deemed a lawful expropriation and still be compensable, which is an interesting question that Chatarine, as I said, agreed to answer. And then I'll take two more questions, and then I'll put it again to the group, and then to the panelists, sorry, and then we'll see. We have another question from Erik Denters, who Tarcisio, of course, also knows well, having worked with him in the past. What is the effect of new environmental treaties on indirect expropriation? It's, I think, quite an interesting point, especially in light of the recent cases initiated against the Netherlands that relate to coal-fired power plants. I think this is an interesting question, important question also from Professor Denters. And then a final question to Sondra specifically. Could you explain further the current arbitral practice on distinguishing between indirect expropriation and non-compensable regulatory taking? Now, this is a good question, but this is, I think, the core of the debate and probably impossible to answer in a couple of minutes. But I nonetheless want to give the panelists the opportunity to discuss this. So let's start with Tarcisio. Let's see if he wants to answer one of the questions. Then we'll move to Chatarine and then Sondra. Again, feel free to answer the question you want. It's absolutely not necessary to reply to all questions. And Professor Nesi, of course, if you want to answer, you're also, of course, very much invited to do so.
Thank you, Eric. I think we should be reasonable, and I try to answer only the first question, which is the more related to my comments. I mentioned the recent developments in state practice, and especially the conclusion of the new investment agreements, because it's interesting to look at the different directions, plural, states are going to. I mentioned CETA. If you look at CETA from the point of view of indirect expropriation, it's very interesting because we have a much more sophisticated provision, putting an extremely high threshold. And the rare circumstances, in my opinion, should not be underestimated from the purpose of treaty interpretation. Rare circumstances, it means that this exercise of regulatory powers is almost always good faith regulatory exercise of regulatory power, no compensation. What is interesting is that some elements typical of fair and equitable treatment are now introduced in the provision on indirect expropriation. There is a reference to the reasonable investor-based expectations in the annex. At the same time, we have the parties squeezing in a very radical manner the scope and content of fair and equitable treatment, which is not anymore called fair and equitable treatment in CETA. But then again, states have dramatically reduced the scope of the application. For instance, they refer to denial of justice, fundamental breaches of due process, fundamental breaches, or manifest arbitrariness, of abuse of treatment, of targeted discrimination with reference to gender, race, and religion. So states are extremely worried about both provisions. They try to reduce the application of indirect expropriation, their exposure to indirect expropriation claims, by drawing the line very favorably to states. And here is the demonstration that these treaties are not inherently in favor of investors. It depends what the contracting parties are prepared to put in the treaty. And at the same time, they have dramatically reduced fair and equitable treatment, which is a trend, because also in other bilateral investment agreements, Morocco, Nigeria, or India agreements, fair and equitable treatment is not called anymore fair and equitable treatment, but now is limited to extremely serious abuses. And this is why, in my opinion, the two should be kept distinct, because there are two independent standards and can develop in different ways. What we can observe now is we have a very fragmented legal framework. And now treaties are going in many different directions, which make even more important dealing with these treaties individually on a case-by-case basis. But I better stop here. Thank you. I will go back if we have time later.
May I say something on that? May I?
Sondra, please go ahead. We have to be a bit brief because
I will.
Running out of time, but please, of course, go ahead.
Yeah, the tendency to conflate in the same, to use the same criteria to assess indirect expropriation and fair equitable treatment that Tarcisio was illustrating in new treaties simply confirm what I observed in case law. I'm not saying that the two standards are the same, but actually that they are assessed according to the same criteria. And the effects, for instance, is one of the criteria emerging from the case law. So, I mean, that's an interesting example on that.
Thanks, Sondra. Catherine, you have the floor.
Thank you. I can give up my speaking slot because I see we only have about 1 minute left. So I think it's best if I pass and you can conclude. Thank you.
Thanks, Catherine.
The same for me, of course, Eric. You can conclude, and I thank you very much for being here.
Thank you. Yes, we have to conclude. We have only 1 minute left. I'm just looking at Sondra virtually to see if there's perhaps one last point you want to make or questions you want to answer, and then we can probably conclude.
Very briefly, what treaty should do in the future in relation to indirect expropriation, I think was one of the questions. Well, as I suggested, clarify the elements when an indirect expropriation occurs, and I suggest three criteria that I'm not repeating right now. And in the book I also suggest to introduce clauses concerning proportionality in the quantum phase to take into account certain specific circumstances that could emerge out of the case to have a more balanced outcome of the arbitration in terms of quantifying the compensation or damages.
Thank you. So, despite the interesting questions that are still coming in, including on the question whether the conduct of the state matters in an indirect expropriation, for the extent of compensation by David Collins, very interesting question also. So I can only suggest to read the book. I think there are several questions that will be probably answered in the book. And also the question by Elie Dentis on environmental law, hopefully we'll have a decision in a couple of years, and this will clarify much. So with this, I want to conclude. Our time is unfortunately up. I want to congratulate again Dr. Faccio for having written this book, for having also organized this together with the Society of International Economic Law. And of course, I want to thank Professor Nesi, Professor Gazzini, and Professor Titi for introductory remarks and for engaging with the substance of the book. Many thanks to all of you. Many thanks to the participants for having been here, listened to us. And I can only again re-emphasize, if you're interested in a topic, look for the book. It's a very important and interesting contribution to the topic. So many thanks, and I wish you a pleasant day.
Thank you, Eddie. Bye-bye.
Thank you. It was a pleasure.
Bye. Bye.
Bye-bye.